We're here today to talk about substantial changes to employment laws that employers should expect under the Biden administration. My name is Holly Goodman. I'm a shareholder in Gunster's Labor Employment Group, and I'm joined here today with my colleague, Anthony Nelson. And our goal is to give you a high-level overview of some of the things that we anticipate to change under the Biden administration based upon President Biden's platform and actions that he's already taken. So we'll start with some of the changes that have already occurred. We're only 2 weeks into this administration, and there's already been a number of executive orders, including several that are going to implicate employers and employment issues that are facing businesses. One of the early executive orders that President Biden issued was an executive order on preventing and combating discrimination on the basis of gender identity or sexual orientation. He, in this executive order, stated that it is the policy of the administration to prevent and combat discrimination on the basis of gender identity or sexual orientation, and to fully enforce Title VII and other laws that prohibit discrimination on the basis of gender identity and sexual orientation. He directed all agencies to review existing orders, regulations, guidance documents, policies, programs, and any other agency actions that relate to Title VII and other laws that prohibit sex discrimination, to consider whether they need to be revised, suspended, or rescinded in order to conform with the Supreme Court's ruling in Bostick last year, when the Supreme Court indicated that discrimination on the basis of sex included sexual orientation and gender identity. President Biden has also directed all agencies to consider whether new action should be taken to combat discrimination on the basis of gender identity or sexual orientation, and has given all agencies only this first 100 days to prepare their plan so that they can make that happen. President Biden has also pledged to sign the Equality Act within his first 100 days. The Equality Act would codify the inclusion of gender identity and sexual orientation in all areas of anti-discrimination laws, including throughout the Civil Rights Act, with Title VII, Title IX, and the laws that affect public accommodations and housing. President Biden has also signified his intent to promote other diversity efforts. One of the executive orders that was issued by the Trump administration last year that caused some controversy was an executive order that limited and prevented certain federal diversity and inclusion trainings. It did get some pushback, especially from the business community, because it extended out not just to the federal government, but to federal contractors as well. And so one of the early actions that President Biden has taken is to issue an executive order that withdraws that prior order, which signifies that President Biden intends to reinvigorate federal diversity and inclusion training initiatives. There's been a number of other changes that the president has made, especially in areas such as workplace safety and health laws, that Anthony's going to talk about with us.
Thank you, Holly. Good morning, everyone. One of the areas where, as you can expect, there's going to be a lot of activity, and we're already starting to see a lot of activity, is with workplace safety and in the health laws and regulations relating to the ongoing pandemic. President Biden, in his first couple of days of office, passed an executive order specifically at protecting worker health and safety. And this order requires OSHA to revise its guidance to employers on the pandemic about what safety measures and what controls should be implemented, in order to combat and to mitigate the spread of the coronavirus. Now, why is this important to employers? Because currently there is no federal standard that requires employers to have a return to work program or anything about mitigating the risk. Some states have adopted it, but there is no federal standard at all. So in this new guidance that has been issued by OSHA goes as far as to say that employers should implement COVID-19 prevention programs in the workplace. Again, there currently isn't a federal standard on this, and this is merely guidance that's been issued by OSHA. However, this was directly in response to the president's instructions in the executive order. So it's almost safe to assume that employers will probably have to, if they haven't already, implement a return to work program or prevention mitigating the risk type of program. I highly encourage everyone to look over this guidance. not only does it mention and talk about some of the steps that employers can take in order to mitigate the spread, it also lays out a series of elements that if you do not have a return to work program already, there are certain elements laid out that employers should consider including in their program. Even if you already have a program that's in place, I still highly recommend checking your program against the most recent guidance that was issued by OSHA. Another thing in President Biden's executive order was he's directing OSHA to increase its enforcement of existing agency standards. The president felt that the previous administration, that under the previous administration, the enforcement actions in connection with the pandemic were perhaps too lax. So he has made it a point to direct OSHA to increase these. And more importantly, the president has asked OSHA to increase these efforts with respect to large employers. So there's a very good chance that not only will we see new guidance coming out later down the line that employers will have to adjust to, OSHA will also be making its rounds to check to make sure that they are being followed. So in light of that, there's a very good chance that we will see a higher number of citations for violations this coming year than we saw in the past year. Another change that we saw has to do with this growing trend of the gig economy. And what I mean by that is the independent contractor rule. This has been widely debated for some time now, and there was a rule that was set to go into place this March regarding how it is employers classify independent contractors. The rule that was passed under the prior administration was going to, in effect, decrease the number of workers that classified as employees. It was based on a certain test that ultimately comes down to the amount of control the employer actually exhibits over an employee. However, President Biden passed an executive order that freezes all regulatory, freezes all pending regulations and those that are set to take effect. So this new one regarding the independent contractor rule has been frozen, and it's likely that it will be repealed. And instead, what will be replaced is going back to a prior version of the rule that was passed under the Obama administration. And under that rule, it is much more likely that you'll see an increased number of individuals that are classified as employees. One thing that the president has made very clear was trying to combat what he considers to be a very fast growing issue with employee misclassification. So as part of that, in order to achieve that goal, the president is going to propose legislation that actually enhances the violations for misclassification cases. So these new violations are expected to go beyond the current penalties that are in place anytime there's an instance of misclassification. We don't know yet what those sanctions or violations look like, but the president has made it very clear in his executive orders that that is going to be part of a bill that he will try to get Congress to pass. And now for some more things that you can expect later in the future, Holly's going to start to cover some of the other areas where we expect to see very substantive changes.
One of the areas that I think that in connection with the independent contractor and an increase in enforcement, I think that the President Biden has also indicated his intention to expand the number of investigators who are within the Department of Labor. And so we are anticipating seeing more investigatory actions coming through the Department of Labor, and anticipating seeing a number of changes in wage and hour laws specifically that are going to impact employers. And I think one that is on a lot of people's radars right now is the increase to the federal minimum wage. Now, of course, for employers in Florida, we know that in the election this last November, a constitutional amendment was passed to increase the Florida minimum wage to $15 an hour. Right now, the Florida minimum wage is sitting at $8.65 an hour. It goes up to $10 an hour in September. What we're seeing on the federal level is a push to increase the federal minimum wage as well. So President Biden has issued an executive order directing agencies to review what federal workers earn less than $15 an hour and to prepare rules for contractors to ensure that contractor employees are being paid at least $15 an hour. So it remains to be seen the speed with which that will be expected for any employers who have contracts with the federal government, whether or not that will impact you at a greater rate or an increased speed from what the Florida's minimum wage requirements will be. We're also seeing on the federal level, President Biden has issued support for the Raise the Wage Act of 2021. This proposes a gradual increase in the minimum wage up to $15 an hour by 2025. This is a little bit more rapid than the Florida minimum wage increase, which is set to hit $15 an hour by 2026. So under the federal proposal, the federal government would raise minimum wage to $9.50 an hour this year, and then make substantial increases of $1 to $1.50 every year between 2022 and 2025 until it reaches a minimum wage threshold of $15 an hour. The other thing that the Raise the Wage Act will do, if it is passed, that will substantially impact Florida employers, is that it proposes eliminating the tip credit by 2027. So right now, employees in tipped fields or in tipped positions, employers are able to get a tip credit. At the federal level, the minimum tip wage is $2.13 an hour. Florida's minimum tip wage is much higher than that. But the Raise the Wage Act is proposing to increase that to $4.95 per hour in 2021, and then increase the tipped employee minimum wage by $2 an hour every year from 2022 to 2026, and then eliminate it altogether in 2027. So that would eliminate all across the board the ability for employers to take a tip credit for employees in service-related jobs, which we anticipate would substantially impact Florida's hospitality industry and a lot of our business that comes in from the hospitality industry. Another thing that we anticipate seeing with respect to wage and hour laws is an increase to the salary basis. So I think most employers remember under the Obama administration, there was a new salary basis test that was proposed. At the time, it doubled the minimum salary threshold for exempt employees who are exempt under the white-collar exemptions of the Fair Labor Standards Act. A federal judge enjoined that right before it became effective, and then when the Trump administration came in, they withdrew that rule and proposed their own final rule. So there has been an increase. I think we all know there's been an increase in the salary basis to what is now $684 a week, which is about $35,500 annually. However, we would expect to see the Biden administration make a push to more substantially increase that salary basis, particularly if the $15 an hour minimum wage becomes law, because an employee making $15 an hour working full-time schedule of 40 hours a week would earn approximately $31,000 a year. So that's going to be a little too close to the salary basis threshold for the white collar exemptions. So we anticipate seeing an increase in the salary basis requirement, especially if that minimum wage law passes. One of the other things that we would also expect to see with that is that we would anticipate the Biden administration to include some sort of mechanism to increase the salary basis at regular intervals. It was stagnant at $455 a week for a very long time before the Trump administration increased it to $684 a week. So we would expect, as was in the prior Obama administration rule, we would expect the Biden administration to propose some mechanism for review or some way to recalibrate on an annual basis the minimum salary threshold for an exempt employee. We're also anticipating seeing more stringent equal pay laws come into effect. President Biden has pledged to support the Paycheck Fairness Act. So under the current Equal Pay Act, an employer can avoid liability for disparities in pay if the employer can show that the disparities are based on a factor other than sex. So what the Paycheck Fairness Act proposes is a stricter requirement that in order to avoid liability for disparities in pay between men and women, the employer must be able to identify bona fide objective factors such as education, training, or experience to justify that disparity in pay. Those factors need to be job related, they need to be consistent with business necessity, and those objective factors must account for the entire differential in pay. If it passes, the Paycheck Fairness Act would also require or would also prohibit employers from restricting employees from discussing wage information. Now, this is already restricted by the National Labor Relations Act because typically wage discussions are considered concerted activity, but the Paycheck Fairness Act would have harsher and more severe penalties associated with any of those kinds of restrictions. President Biden has also signaled an intention or support for expanding coverage under the Age Discrimination in Employment Act. And so most employers are aware that there is a difference between Title VII and the Age Discrimination in Employment Act and the tests that are used to decide whether or not a decision was discriminatory. So under the Age Discrimination Act, the Supreme Court has stated that there needs to be but-for causation in order for there to be liability. And this means that an employee has to prove that their employer took an action because of their age. No other reason. If they had been younger, the action would not have happened. Their age is the only reason. Title VII, other anti-discrimination laws have a more flexible standard that look at whether or not the protected characteristic was a motivating factor. And so President Biden has indicated his support for modifying the Age Discrimination Act to track the language of Title VII to remove this stringent but-for causation standard. The president has also given broad support for expanding and broadening paid leave. I'm going to preemptively apologize. My dog just broke into the room. So the President Biden has given support to expanding and broadening paid leave. He supports providing up to 12 weeks of paid FMLA leave for eligible employees. There's currently a bill that was introduced in prior years called the Family and Medical Insurance Leave Act. They call it FAMLY for short. It would create a national family and medical leave insurance fund to provide workers with a portion of their wages for up to 12 weeks for qualifying leaves, same qualifying leaves of FMLA, and the pay would be at 2/3 of their wages. The act proposes that it would be both employers and employees who contribute into this fund through, similar payroll taxes and deductions that we support Medicare or Social Security. President Biden has also expressed support for permanent paid sick leave outside of the Families First coronavirus leave that is on the table with the current or the next round of stimulus. President Biden has also indicated his support for the Healthy Families Act. The Healthy Families Act that's been proposed in Congress in the past would require employees to earn 1 hour of paid sick leave for every 30 hours worked, up to a maximum of seven days per year, 56 hours or 7 paid days of sick leave per year. So we anticipate that the president will be looking at increasing those paid leave requirements. We're also expecting to see some more changes in workplace health and safety that Anthony is going to address.
Returning to the issue on worker health and safety, specifically the executive order that was passed, the biggest implication from that, not only is OSHA required to issue the guidance, which has been issued to employers, the executive order also directs OSHA to consider whether any emergency temporary standards on COVID-19, including with respect to masks in the workplace, are necessary. And if OSHA decides that they are, which most people are predicting that they will, these new regulations will be issued by March 15th of this year. Again, there is currently no federal standard that's put in place, and it's expected that come this March that there will be one. So what can you expect in this federal standard? One thing for sure, as you mentioned before, is a written COVID-19 response plan or return to work plan. Again, OSHA has already laid out a lot of points and elements and other commentary that employers can use to start to prepare these plans. Again, if you don't have one in place now, it's almost certain that they will be mandatory. The second thing is reporting requirements and notification requirements. It's expected that if there is some sort of federal standard from OSHA, that it would require employers anytime an employee or a contractor or other third party test positive on site, the company would have a duty to report that to help with contact tracing efforts to their local or state health departments. Going a step further, it's expected that the new regulations would also require employers to notify employees and others that came into contact with the individual who contracted the virus. So again, these are reporting requirements currently not in place for a lot of employers, but there would be a federal rule that would make it applicable across the board. Another thing that you can expect from this federal standard is training requirements, very specific training requirements that will be adapted and tailored to certain industries. So if you are in an industry that has a certain unique, set of circumstances that separate you from others, there's a chance that there will be specific training requirements for employers to require of their employees, including instructions on how to carry out the new response or return to work plan. Again, it's almost certain that OSHA will make the determination that a federal standard is needed. So it is not too early to begin to take those steps necessary to get that in place. Another big thing that we're seeing with worker health and safety has to do with unemployment. So the president is asking the Department of Labor to consider clarifying whether workers have a federally guaranteed right to refuse employment at any place that jeopardizes their health and safety, yet they would still qualify for unemployment insurance. This would be a big change. There currently hasn't been anything beyond what the president has laid out in his initial plan when he was campaigning. But if this were to go into effect, you could imagine that you could start to see a wave of complaints by some employees that have to do with unsafe working conditions. And again, despite an employee being terminated or refusing to come to work because of these unsafe work conditions, they would still be eligible to collect unemployment insurance. But we're waiting to see more come out about that, and we'll continue to monitor it. Returning to the theme on the gig economy, we talked about independent contractors. Another related issue where it's almost certain that we will see a change is who's considered a joint employer. So currently, there is a more narrow test that was proposed under the Trump administration, which again dealt with direct and immediate control over an employee. The new proposed rule is actually, again, going back to a prior Obama-era decision that defines a joint employer as one that exhibits indirect control or has the ability to exert control. Again, at the end of the day, this is expected to broaden that definition of joint employer and sweep more companies into the definition of joint employer. And then lastly, one of the changes that the president has been adamant about is trying to increase competition in the labor force. And one of the measures that he is proposing to help achieve that goal has to do with changes to employment-related agreements. His first initiative was he wants to eliminate non-compete and no poaching agreements. So under the little bit of information that he has issued on this topic, the president would not do an across-the-board prohibition on non-competes and no poach agreements. Instead, he would make only those non-competes that are absolutely necessary to protect a narrowly defined category of trade secrets, which oftentimes many people still to this day really don't know what constitutes a trade secret. So there's a very good chance that this would be a very, very limited exception for what would be a permissible restrictive covenant with competition. And then further, to promote this goal of increasing competition in the labor force, the president also wants to ban mandatory individual arbitration agreements and class action waivers. Typically, whether it's in an employment agreement or in a severance agreement, oftentimes, employers will elect to put in there a mandatory arbitration provision for employees. Oftentimes, there's many benefits to going to arbitration. However, the president would make it a point to prohibit mandatory individual arbitration agreements, meaning if you still wanted to do it jointly or pursue some sort of joint action, employees could and they would have that right to not only pursue it jointly, but also to have their day in court rather than being forced to arbitration.
So as we continue to see things coming down the pipeline, we will be keeping our clients posted if we do our employment law alerts. If you're not already receiving those alerts, then please, by all means, you can email myself or Anthony to get on the list for us to make sure that you receive our employment law alerts when we send out notices about changes or major changes in the direction of the employment laws rather. I would anticipate seeing more of those with the change in the administration because President Biden has been so vocal about worker protections being one of his top priorities and about diversity and inclusion being one of his top priorities. So we do expect to see more regulations coming down the pipeline, changes in the way that the Department of Labor will be interpreting the wage and hour laws or additional changes to the wage and hour laws. And as Anthony was just talking about, even changes to things like what you can include in your employment agreements. So we are monitoring all of those changes and we'll keep everybody posted. I still have not received any questions in the chat, so hopefully that means that everyone here today was just able to digest. I know that we've provided you with a lot of information and there's a lot to keep your eye on, but we will keep you posted as best as we can. And if no one else has any other questions, then we'll go ahead and let everybody go for the day and have a good afternoon. Again, this will be posted if you want to watch it again or forward it to any of your colleagues. This webinar will be posted on Gunster's website and Gunster's YouTube site as well after we conclude today. Thank you so much for your time. We really appreciate you. If you have any questions, both Anthony and my contact information is on the screen. We'll leave that up for just a minute in case you need to write it down. And we thank you for your time.